next to custody, probably the most often argued about area of family law is division of property. In Texas, we call marital property community property, which confuses a lot of people because they think of community as being their neighbors or their town, and yet in Texas, community means the marriage. So Texas is referred to as a community property state. There are several other community property states. I think Washington State is one, Tennessee is one. But it basically provides that all of the stuff accumulated during the marriage belongs to the marriage or the community. There is not an absolute presumption that each side gets 50% of that, although in practical outcomes, it's often divided pretty much that way, depending on some other factors. Income, ability to earn income, who's got the kids, some other things. But the notion is that the marriage owns the stuff that was accumulated. What other kinds of property can there be besides community property? Well, there's something called separate property. And separate property is anything that you owned before marriage that was gifted to you during the marriage, or you inherited, whether you were married or not. So you start with the presumption that everything you got at the time of divorce belongs to the community, and then you have to pull out those things which either you owned before marriage or that you inherited during the marriage. The difficulty with that is that if you have a long marriage and you're not a pack rat, then you may not have all of that paperwork to prove. And so you start with the presumption that everything you've got the date of divorce belongs to the marriage, and you've got to trace, is the term of art, the stuff that you want to claim shouldn't be part of the marriage. If it was more recently acquired, then you may have that paperwork. But if you're looking for checks or records that are more than 7 years old and your bank didn't keep them, or the stock was sold and a piece of land was purchased, then it may be more difficult. The notion of things belonging to the marriage is common to a lot of other states. Equitable distribution is what they refer to in Virginia, but there's some differences. The community property assumes that the stuff that was acquired, regardless of whose name it's titled in. So I often hear people say, well, that's my car, or that's my gun, or my collection.
My boat,
my plane, my cows, or horses. Don't get me started on the horses. But those things that, even if they are titled into one party's name, they still belong to y'all. Even if you kept separate bank accounts, they still belong to y'all. Your paycheck is my paycheck, and my paycheck is your paycheck. So it belongs to us if we're married, regardless of whose name it's in, and regardless of who earned it. That is not what people want to believe or what people think is the law. So sometimes convincing folks that it doesn't matter, that it doesn't matter whose name it's in, it is y'all's. Oh, it's often disagreed. I mean, I will have a client telling me that they specifically kept their money separate because they thought it belonged to them. This was my paycheck. Nothing else but my check went into this bank. It's mine. You don't have signatory rights. It's mine. No, it's not. It's y'all's.
Okay.
If you want to say that there's any money in there, and it gets worse, depending on which side you're on. In Texas, income from separate property is also marital. So if I have a rental house that I owned before I met you and before we got married, and I have income from that rental house, even though it's my separate property and there's no question, I got the paper, the deed, I can prove that I owned that before we got married. The income from that house is ours. And so sometimes the fight or the argument between people is a misconception of what the law is, because they don't agree with the law. They don't think it should be that way, but it is that way. The burden of proof is on the person who wants to prove that it is other than community property. So if I'm going to claim that I owned something before marriage, then I better have a piece of paper that shows that. If I'm going to claim that my great Aunt Louise died and left me $10,000, I better have her something from her estate, or the check going in, or something happening. And then you get into problems with commingled assets. I'll give you an example, well, or hybrid assets, things that are part and part. So I own a car and we get married, and after we're married, I trade the car in, and I get $5,000 for my trade-in towards a $30,000 car. So 1/6 of that new car is my separate property. Well, unless you bought an antique car or some specialty car, that car is not going to increase in value. It's not going to appreciate. And so now we're getting divorced, and the $30,000 car may only be worth $15,000. My separate interest in that car is still 1/6. It's not the $5,000, it's 1/6 of whatever the value is. Conversely, that's true though with something that does appreciate. So I've got a $10,000 CD before we get married, use it to put down on the house, and that's a tenth of a $100,000 house. Then I've got a 10th separate value of now what is a $200,000 house. And there are circumstances all the time where both parties had $10,000 and somebody put it down on the house and the other one paid for the honeymoon, and they thought everything is square, and the person who put it down on the house has a claim to an asset, and the person who put it down on the honeymoon may own the pictures. But it's not the same. And it doesn't matter what you intended it to be, it's what you did. So, you know, that helping people understand how a court is going to view their stuff may help people get to the table to mediate and to settle a case. But the first step is trying to agree on what our stuff is. So when I'm working with a couple, a lot of times I ask them to make a list and see, can you agree? Can you agree that this is your stuff? Can you agree that he owned this or she owned it prior to marriage, or it was gifted to them, or their parents bought it for them, or whatever? And then what's the y'all stuff together that there may be a separate component in? But once you agree on what that pot is, it's much easier to divide. People still fight over the green couch or the blue vase, but you cut down on a lot of the arguments if you can use these rules to categorize your stuff, and then you know what you're fighting about, because that's what the court has to do. The court has to characterize it and decide whether it's a community asset or a separate asset, or a part and part or hybrid asset.